The debate surrounding AI and legal compliance remain as heated as ever, with web scraping being one of the main ways to acquire data for training AI models. It has become a big part of the conversation too. Is it legal to scrape data to train AI models? Does scraping publicly available data violate privacy laws like GDPR or CCPA? Hi, I'm Viktorija, Head of Product Legal at Oxylabs, and today I will walk you through some common questions in the context of web scraping, AI, and legal compliance. So let's begin. Question 1. What is the current legal landscape surrounding web scraping? Web scraping operates within a legally complex and fast-evolving space. There's no single law that regulates web scraping. Instead, its legality depends on what kind of data you're scraping, how are you scraping, and what it's being used for. More specifically, the laws that often comes into play are copyright law, contract law, privacy law, and in the US there are also unauthorized access law like Computer Fraud and Abuse Act, known as CCPA. So when you're analyzing data scraping activities, context really matters. The rise of AI has added a new layer of complexity. As AI models have often trained on large amounts of scraped data, new legal, ethical questions are emerging. In response, countries are introducing AI-specific regulations to address concerns like data privacy, safety, discrimination, and IP rights. One of the most comprehensive frameworks to date is AI Act in Europe, which is already in force and will become fully effective by 2026. And just like GDPR, the AI Act is extraterritorial, meaning that even if your company is based outside Europe, the law still applies if your AI models are used within the EU. Governments around the world are following with their own regulations, recognizing AI growing impact and the urgent need for oversight. So, what legal risks might a company face when scraping data? A common concern is copyright infringement. For instance, scraping and reusing protected content like articles, images, or databases. In contrast, scraping factual data such as product prices or technical specifications typically falls into a lower risk category. Violating terms of service is another risk. Courts generally treat click-wrap agreements, where a user actively clicks "I agree" as enforceable. Meanwhile, browse-wrap terms, passively linked at the bottom of the website, are less likely to be upheld. That's why focusing on scraping publicly available data only, without scraping under the login and accepting terms, can be a very effective strategy for mitigating this risk. Privacy is another big question, especially under laws like GDPR. Imagine scraping a publicly available contacts database, thinking it's a fair game, only to discover that under GDPR, even publicly available personal information is still protected. This means that you have to think twice before deciding to collect this kind of information, and if you do, it's important that you can justify why you're collecting and processing personal data. You also have to establish a clear lawful basis, implement all necessary requirements, and minimize the amount of data collected while ensuring it is securely handled. Meanwhile, CCPA in California works differently. It does not apply to personal data that people have made publicly available themselves. As a result, scraping publicly available personal data under CCPA carries less risks. Let's not forget ethical considerations. Companies engaging in web scraping should act as responsible citizens of the web, ensuring their actions neither strain nor disturb the targeted website. Overloading servers and extracting excessive amount of data not only crosses ethical lines, but also may significantly harm a company's reputation. Data is power, and with great power comes great responsibility. Ethical web scraping isn't just about following the rules. It's about respecting the ecosystem you're benefiting from. This involves sticking to website usage limits, choosing ethical and responsible use cases, and designing systems that prioritize fairness and accountability. So, how does copyright come into play when using scraped data for AI? The use of scraped data for training AI models has certainly sparked a wave of legal uncertainty. At the heart of the debate lies the question of whether using copyrighted material in AI training qualifies as a fair use under the US copyright law. Courts considered several main questions in making this determination, such as: is the use transformative? What is the quantity of data used? What is the impact for the original work? Several high-profile lawsuits are addressing the complex intersection of AI and copyright law. The Authors Guild has sued OpenAI, alleging that ChatGPT was trained on copyrighted works without authorization. In the meantime, Getty Images started legal action against Stability AI for allegedly using its images without permission to train the Stable Diffusion model. As another example, three artists have filed a class action lawsuit against Stability AI, Midjourney, and DeviantArt, claiming that their AI tool used billions of images scraped from the internet without the consent. The New York Times has also sued OpenAI and Microsoft, accusing them of training AI models on its copyrighted articles without approvals. In these cases, copyright holders accuse AI developers of exploiting protected content like images, text, and codes to train their model without proper authorization or compensation. Meanwhile, proponents of AI argued that training models constitute fair use, as AI system analyzes and learns from data rather than directly replicating it. They emphasize that access to large volume of data is crucial for development of advanced AI models and the advancement of the technology itself. In February 2025, the first ever court decision on AI and copyright was issued in Thomson Reuters versus Ross Intelligence case. The court found that Ross's use of Westlaw copyrighted material to train its legal research AI tool did not qualify as a fair use. But context was a key. The AI system was non-generative and created a directly competing product without adding creative or transformative value, thereby harming the market for Thomson Reuters services. However, the broader and still unresolved question is whether using copyrighted data to train generative AI, such as ChatGPT, could qualify as a fair use. So, until courts establish clear guidances, the tension between promoting innovation and protecting intellectual property rights will remain one of the most closely watched issues in the AI field. The best way to manage legal risks when scraping data for AI is to take a proactive, legally informed, and ethical approach. My advice is to first clearly identify type of data are you scraping, whether it's publicly available, personal, or copyrighted, and then understand the specific law behind. Additionally, you should clearly define the purpose and scale of your scraping activities. For instance, while publicly available data may seem safe to use, privacy laws like GDPR can still apply. Also, using copyrighted materials for AI training demands careful evaluation for fair use or licensing obligations, as legal standards in this area are still evolving. Moving on to the question whether scraping companies can help their clients follow the rules, it's crucial to mention that it requires an active effort from both the company and the client. Web scraping companies play an important role by providing high-quality product designed with compliance in mind, including ethically sourced proxies. However, it's also crucial for clients to make informed decisions about their own specific use case. This involves having an understanding of the legal regulations that apply to their actions. By fostering open communication and commitment to compliance, both parties can minimize risks and maximize value of scraped data in a lawful and sustainable way. Let's try to summarize where things are headed with AI and web scraping. AI is evolving fast, and with its heavy reliance on data, the legal system is struggling to keep up. Ongoing debates about the legality and ethics of scraping, especially in AI training, are gaining attention in courts. Many of these open questions are likely to be addressed soon, bringing more clarity. The road ahead may be complex, but it also offers opportunities for businesses to lead responsibly. Companies that prioritize compliance, transparency, and ethical practices now will be better prepared to compete and excel as the rules evolve. As courts and lawmakers address the current uncertainties, this transformative period will ultimately define how we balance innovation with legal and ethical boundaries in the AI-driven world. That's it for today. I hope this video was useful and I was able to answer at least some of your questions. Don't hesitate to leave your comments below and subscribe to Oxylabs for more content like this. Thank you for watching.